Okay, Assalamualaikum warahmatullahi wabarakatuh once again. Today we are going to start with the discussion with the lecture on the topic general and special damages in personal injury cases. So having said so, cases related to fatal accident or death cases, that one we reserve it for the final part of our lecture. The third part of our lecture. So basically, the main content of the slide belong to Dr. Farhin. She's one of the lecturers in the team of torts 2, but I have done some editing, quite substantial editing to the content and to the slide as well. So inshallah, you'll be getting a copy of the slides later, so no worries. Okay, general and special. All right. So in the last lecture, we touched a bit on the case of Someone Home and Dr. Kadir Ibrahim Shah, judgment by federal court. But the gist of the case is that the court made a distinction. Okay? The court distinguished between general and special damages. So in essence, okay, general damages, the acronym for this like damages. So general damages, it represents, okay, it denotes, okay, artificially the gravity of loss. So the more serious the injury is, that the higher will be the amount of compensation. So it will commensurate as far as possible the gravity of the injury or losses. But in what way it differs from general and special damages here? So special damages, it is more on pecuniary loss. And then most of the time, okay, the plaintiff, okay, the party is allowed to claim the exact amount. But again, it has to be strictly proved. Okay, we go back to the case of Someone Home, even though we have discussed in the earlier lecture. So the importance, okay, the significance of the case is that in this case, federal court, okay, the highest courts in Malaysia at the apex, okay, approved the judgment. And the court also distinguished the two kinds of damages, because in Civil Law Act, it doesn't say clearly, okay, the differences here. So that's why we need case law to interpret the provisions of the law. So in this case, the court said clearly, okay, expressly, special damages consists of, this is example, okay, consists of out-of-pocket expenses. For example, hospital bill, okay, you can really prove it, okay, and we can quantify exact amount. Cost of prosthesis, okay, artificial limb, facilities, okay, wheelchair, or even cost of nursing care, loss of earning, okay, all under special damages. But for general damages, they comprise of damages for pain and suffering. So pain and suffering, we cannot really quantify, okay? And we also have loss of amenities. We are going to discuss after this what is meant by loss of amenities and the like, okay? Meaning whatever similar to pain and suffering and a loss of amenities, okay? But most of the time, this is the two common examples, okay, of general damages. It also includes future loss of earning, but the specific calculation. But again, we cannot really tell, okay, exact amount. We just make some calculation, estimation, okay, loss of earning, as well as loss of earning capacity. So all of these things we are going to discuss throughout our lecture for this particular topic. And this is the chart, okay? We are going to cover everything in the box here. In the box there, we have few boxes here. So the main section, so we are going to look at section 28A. A is amended, okay, as amended Civil Law Act 1956. So the first part will be general damages. It covers pain and suffering, okay, loss of amenities, mental anguish, and the injury itself. Injury itself, we are going to cross-refer to compendium. Okay, after this, I'm going to show it to you, and later I'm going to give you a copy of the compendium. And then after we are done with general damages, we move to loss of future earning, or acronym for our, for the purpose of the discussion is LOFE, okay, loss of future earning. And the formula, okay, the calculation is based on multiplicand times by multiplier. And later, okay, after we are done with the first two, then we are going to focus on special damages, in which it covers loss of earnings, actual loss of earning, and out-of-pocket expenses like medical costs, okay, medical expenses, nursing care, and also others, which are more or less similar to medical and nursing care. So that's basically the things we are going to cover. It's like outline, okay, of our discussion. Okay, first we go to, okay, here, right, you can see pain and suffering under general damages. So now you focus on general damages, and the first one is pain and suffering, and you can use acronym PS lah, okay, pain and suffering. So what is pain and suffering? So for pain and suffering, the plaintiff is asking compensation for physical pain, okay, and then it covers as well mental pain, mental suffering, okay, due to the injuries that he suffered. Remember, okay, we are discussing personal injury, meaning that here the victim or the plaintiff survived, okay, after the accident, right, after the injury. Meaning here he doesn't die. If he dies, then the discussion will be under different categories or different topic altogether. Okay, and then how do we calculate? Okay, how do we award? How do we measure? So the age of the plaintiff, okay, and gravity, how serious it is. Okay, gravity of the injury sustained by him or her will be taken into account. So the court will take that into account in order to award reasonable amount of damages. And what if plaintiff first survived and after a few days, after some time, or maybe after a month, okay, he died. So if the plaintiff dies few days after the accident, okay, the legal representative, or the name is the estate, okay, that's the term, the estate is entitled, okay, to the claim, to the award, okay, of pain and suffering sustained by the deceased till the date of the death. I mean, it is allowed, okay, during his lifetime. For example, he survived 1 day or 2 days. So the claim for pain and suffering can be made for that particular 2 days period. Okay, that one actually will fall under the discussion of the death lah later, and specific section of Civil Law Act is section 8. But for today's discussion, we are only focusing on section 28A. Okay, later I'm showing you the provision. Okay, and still in relation to the third bullet there, okay, just now the plaintiff dies a few days after the accident. Okay, another queries here. What if, all right, what if the death was instantaneous, instant, I mean die straight away on the spot at the scene of the accident? Can the plaintiff claim for pain and suffering? Cannot, okay? So no claim for pain and suffering in that particular cases. Okay, another issue. What if plaintiff is in coma? Okay, accident happened and he fell into comatose, okay, situation. So we have the case which discuss this. Okay, it depends. Okay, it depends on the situation of coma here. Sometimes is it semi-coma? Can feel the pain or not? Can respond or not? Okay, so we have the case of Tangavelu and Chia Kok Bin, 1981. And our main reference for today is Civil Law Act 1956. But we have amendment. Okay, the law, the provision of the act was amended in 1984, so that now we have section 28A. Here the amendment was included in year 1984. But we also have another major amendment recently, okay, in year 2019, I think. All right, but we are going to discuss the latest provision, okay, as it stands today. I haven't showed to you section 28A after this. All right. Okay, we go to Tangavelu first. Okay, Tangavelu is about plaintiff in coma. We are still discussing pain and suffering. Okay, to ascertain, can we allow him the claim for pain and suffering? Okay, or the damages for pain and suffering. Okay, in Tangavelu and Chia Kok Bin here reported in year 1981. So plaintiff's son, he was 13 years old, very, very young, okay? And he was killed in an accident, but then he wasn't killed on the spot. He didn't die on the spot. So before he died, okay, he was in coma for some time, but then even during coma, he was not totally unconscious. Meaning that here, sometimes he was conscious, okay? Meaning that he gave response to whatever treatment or to whatever task here. And then later he died. Eventually he died. So when the case was brought to the court, and then the estate was trying to claim for pain and suffering when the plaintiff was in coma, okay, when the son was in coma. So the court held that yes, okay, there was an element of pain and suffering, because for this particular case, okay, the son, okay, who died later, was not totally unconscious. So sometimes actually he gave response, meaning he could feel the pain even though he couldn't speak. Okay, so for the year 1981 here, you can see the amount. He was awarded, okay, the deceased was awarded 20,000 for pain and suffering, and usually it is combined with loss of amenities. Okay, we haven't discussed loss of amenities Yeah, so 20,000 in the year 1981. So you can guess if the similar case happened in year 2022 now, I mean, will the court will be justified? Is it justifiable, okay, to award the same amount of money? Okay, all right, that's the question. Okay, another leading case, okay, other than Tangga Value is Marapan and Siti Rahma. Marapan Siti Rahma, it is applicable. I mean, the case is important because it will explain to us, it illustrates a few principles related to personal injury. Okay, what happened in Marapan and Siti Rahma, reported in year 1990, and then the judgment was by Supreme Court, okay, equivalent, I mean, at the same level with a federal court. So what happened in Siti Rahma here, this is a appeal case. So Siti Rahma, plaintiff, she was knocked down by a motor car, okay, and then as a result of the accident, she suffered severe head injuries, okay, not to any other limb, head injuries, and it resulted in complete paralysis, meaning here she became paralyzed, okay, of all her 4 limbs. So I mean bedridden lah, basically, okay, cannot move whatsoever. So for this particular case, okay, now in year 1990, okay, and then she became paralyzed for the whole lifetime. Okay, so in this case, plaintiff, the court awarded RM 180,000, okay, for pain and suffering and loss of amenities. Okay, if you compare with Tangga Value here, I mean, only a few. It's not really, I mean, just few days, I think. He was in coma. That's why the amount was 20,000. But here, lifetime, okay, lifetime, he will be suffering from pain and suffering as well as loss of amenities. So that's why the amount allowed here was 180,000. But still, okay, whatever amount of money here, it won't give the plaintiff her normal life back. So at least he got something, compensation here. Okay. After discussing loss, pain and suffering, okay, another, it's like twin claim. Here, loss of amenities comes together, okay, both under general damages. Okay, what is meant by loss of amenities? So the acronym, okay, for the purpose of discussion is LOA. So loss of amenities. Basically, loss of amenities, it refers to loss of enjoyment of life, of our normal life. Okay, we can walk, we can run, we can eat. I mean, it's our normal life. Okay, and then what if this normal life, enjoyment of life here is taken away? I mean, it's gone. All right. So in that particular situation, plaintiff will be entitled to be compensated, okay, to be awarded for his or her loss of capacity to engage in activities, okay, which he was able to enjoy before he was injured. So this is what we mean by loss of amenities. Okay, how do we, they go together. They are combined. Okay, the claim is made together, but they are different still. Okay, it refers to different claims altogether. So now we are making comparison. Okay, we are showing the difference, pain and suffering and loss of amenities. And we are we are now referring to House of Lords case, common law case in West and Shepherd, okay, 1963. Because in this case, House of Lords stated, okay, made it clear the distinction between pain and suffering and loss of amenities. Okay, what's the difference here? What's the difference in terms of the rule, okay, to be allowed, to be entitled to claim for these two claims here? So the court said that, House of Lords said that in pain and suffering, the plaintiff, in order to be allowed to claim, he must be aware of the pain. Okay, if he doesn't feel the pain, then no claim for pain and suffering. I mean, you don't feel the pain, so how come you claim for pain and suffering? But for loss of amenities, okay, damages, compensation are awarded for the facts of deprivation. I mean, you are deprived to do your normal activities in life. So it doesn't matter. Okay, it's not dependent on awareness. Okay, even though you are in coma, you can still claim for loss of amenities because you are being deprived, okay, of your normal enjoyment of life here. So that's the difference basically. Okay, so in another case, another common law case, okay, just now we have the West and Shepherd. Now Wise and K, okay, 1962, Queen's Bench Division. So in this Wise and K's case, the plaintiff actually remained unconscious for so long, okay, for 3.5 years. And then throughout 3.5 years here, obviously, okay, she had been deprived, okay, of all attributes of life itself, obviously, okay, for so long, for many years here. So she was awarded 15,000 pounds sterling, okay, for loss of amenities. Okay, he was unconscious. I mean, she was unconscious, so she was in coma, so cannot claim for pain and suffering, but she could claim for a loss of amenities. Okay, it depends on whether the plaintiff, okay, the victim was aware, can feel the pain or not for pain and suffering. But for loss of amenities, meaning that here it will be awarded in all kinds of cases most of the time, because the facts that, I mean, the court look at the facts that the plaintiff or the victim or the claimant was being deprived of the normal, to enjoy the normal life lah, basically. All right, okay, we come back to Marapan Siti Rahmah, okay, which was decided in year 1990. So in year 1990, okay, the court allowed the claim of 180,000 for pain and suffering and loss of amenities because she became paralyzed for the whole lifetime. Okay, if we refer to cases, okay, some cases, trend of cases, in year 1999, I mean 10 years after, more or less 10 years after, okay, the court increased the amount up to 220,000. So there's an increase in the amount. So now the big question, what if the similar case happened in year 2022? Okay, what will be the amount? Okay, in order to know, okay, we have to look at the latest cases lah. Okay, to know the latest quantum awarded by, for example, awarded last year, okay, 2021, or even awarded early this year, 2022. Okay. And another way of looking at it, okay, how the court decided on that is actually to refer to, this is the hard copy, okay, Mala's Digest. It is available in the library, okay. But nowadays we prefer to have online, online version of all the references. But obviously you have your online database Lexis. You can simply click and then search. You see, oh, this is the amount awarded by the court. Okay, I'm showing you the compendium after this. Okay, when we come to the injury itself. Okay, this is just for you, something for you to think about. Okay, what could be the amount awarded in year 2022? Okay, now mental anguish. Okay, so mental anguish refers to the grief, okay, the suffering, okay, but mentally, not really physical. So this is the grief faced by the plaintiff, knowing that he or she has a shorter period to live. Meaning after the accident, the court said, the doctor said, oh, because of the accident so serious, we estimate that you can survive or you can live up to 2 years maximum, for example. So now it's shorter period to live. Okay, it could be a few years or it could be a few months. Okay, so this one, okay, knowing this fact, it causes mental anguish, okay, grief. Of course, the person, the party will feel stressful, okay, all those things. Okay. And then another name, okay, of mental anguish is that it is also referred to as loss of expectation of life. Okay, that's the proper name. Okay, or if you want to use the acronym, LOEOL. Okay, loss of expectation, EO of life. Okay, now I'm showing you section 28A. Now we are looking specifically to 28A, 2A, and 2B. Okay, I need to stop share and I reshare. Okay, I'm showing you, I'm giving you the copy as well later. Where is it? I think I have opened it. Okay. Yeah, I have opened it. Can you see my screen? Cannot.
Not yet, doctor.
I have opened but cannot. You can see my screen, isn't it?
Yes.
Yes, doctor.
Okay. All right. So now this is Civil Law Act 1956, which has been amended in year 2019, if I remember correctly, but quite recent. Okay. And now we are focusing on section 28A. You can see the word A, okay, capital letter, as amended. Okay, after the amendment in the year 1984. Okay. And now we are looking at 28A. 2 kan tadi, isn't it? 2A and B. Here, 2A and B. So 28A here, okay, it revolves around damages in respect of personal injury, which is our topic. Okay. And you have a number of pages actually, okay, to go through lah. 1, 2, 3, not many lah here. All right, 3 pages. Okay. Now we want to focus on 28, okay, A, subsection 2, okay, A and B. All right, what does it say here? In assessing damages under this section, no damages, meaning they cannot claim lah. Okay, it start with no damages shall be recoverable in respect of what? of any loss of expectation of life just now, okay, caused to the plaintiff by the injury, okay. But then we read together with B. If the plaintiff expectation of life has been reduced by the injury, okay, the court, now the task is on the court, okay, discretion on the court in assessing damages in respect of pain and suffering, okay, caused by the injury. So the court will take, shall, so it's strong word here, the court must, okay, must take into account any suffering caused or likely to be caused by awareness that his expectation of life has been so reduced. So meaning that here, even though LOEOL is no longer allowed, but it can be allowed together, okay, part of pain and suffering. In the here, mental anguish here, okay, knowing that the life is become shorter, so it could be part of pain and suffering. So the amount will be higher. I mean, the year is combined. It is included together in pain and suffering, and not in the separately. Okay, not in a separate claim lah. Basically, separate head here. Okay, so we go back to the slide and we come back later. Okay, we need to come back here again after this. Sharing again. All right, so we were here just now. So just now we read together 28A, 2A and B. Okay. All right. Okay, this one just now. Okay, we read already this one. Oh, I have to make it in in white, in white font here. Okay, now the fourth category, okay, under general damages is the injury itself. The injury itself. I mean, for example, a cut in the hand, for example, or the hand is injured. All right, injury in the fingers. Okay, this is what we mean by injury itself. Okay, pain and suffering, it refers to the feeling, okay, the pain that you suffer, okay, the pain that the plaintiff suffers. But injury itself, with regards to the limb, okay. So here the injury itself is a proper subject, okay, for compensation, apart from the three earlier ones that we have discussed, okay. For example, okay, loss of eye, loss of a limb basically, or injury to the limb, loss of eye, okay, broken hand, broken leg, okay, shortening or puncture, wound, okay, laceration, okay, laceration is deep cut, okay, or tear in skin lah, okay. So now we want to check, okay, you see the box there. Sorry, I'll change the color, okay, after this. Check the latest judicial tariff. How do we know the judicial tariff? We have compendium, which is a guide. It's not really binding, but then it's a guide, and the court usually use it, okay, in order to claim. Okay, loss of eye, how much? Okay, how much the claim can be allowed, right? Okay, I have to stop share and reshare, okay, because I don't know how to move from one screen to another. I did try last time, but then you cannot see my screen if maybe I don't do it correctly. Or can I share? Where is compendium? It is supposed to be, hold on now. Here. You can see compendium. Okay, all right. Can you see the compendium now?
Yes, doctor.
Okay, all right. Okay, compendium, it has been revised from time to time. Okay, last time we have the version of 2010. So now the latest version, okay, after the revision, this is actually, who did this compendium? Bar Council. Okay, so I got this copy from Bar Council, and this is the latest lah. Okay, they haven't, I mean, they are, usually it is ongoing a process of revision. So after some time, they compile everything, all the revision, and they make a revised compendium. So the latest revised compendium, okay, compendium that we have, I mean, the full name is Revised Compendium of Personal Injury Awards. Okay, it has 15 pages, quite long, but you don't have to read all lah. You just refer to, okay, this is as at 6 July, and it is enforceable. Okay, it is valid until nowadays. Can see here, okay, the contents. This is the categories. Okay, I mean, it has orthopedic injuries. Okay, all the limbs. It has internal injuries. It has external injuries, and it has skeletal system. Okay, quite detailed actually. All right, we go for example. The first one. Okay, that's the first. This is page 8. Okay, orthopedic. So it refers to the skull or the bones, can right here. All the medical term. Example here. Any fractures. Okay, it depends on the degree, how grave it is, how serious. If not so serious, 18,000. Okay, if serious, high degree, 30,000. Okay, we go specific limb. Okay, this is facial bones. Okay, all the scientific term or medical term. Okay, teeth. Okay, what if the plaintiff lose the teeth, for example, loss of tooth? One tooth, the amount, of course, actually it doesn't really tell this is the value of your tooth, but this is compensation, all right? Okay, we have 10 minutes left. Okay, we want to see the, all right, here, arm. Okay, this is the compensation for arm. We are looking at eye kan just now. Okay, this is arm. Okay, for example, amputation of all fingers. Okay, what could be the compensation? Okay, if the plaintiff lost all the fingers, okay, the amount of damages would be between 36,000 to 55,000. Okay, even though plaintiff now becomes a disabled person, but that's the amount that he can claim. Okay, for one hand lah. All right, maximum 55,000. You can say, oh, not much, but that's the amount. All right, even 1 million cannot replace the loss of the limbs. Okay, there's no replace of the limb. Okay, we are looking at eye kan just now, the eye. Let me, sorry, I have to scroll down. It makes you dizzy ke? I'm scrolling down. It even has compensation for private organ kan, actually. Okay, body, you can have a look later. This is brain, internal injuries, brain. So for injury to the brain, for example, bleeding of the brain or whatever, injury to the brain, so this is all the amount. Here. Okay, bedridden state. That's why Marapan Stirama, okay, the amount was awarded quite very big kan here. So this is the latest, those days may be lower. Okay, that's why she got 180,000. But now in today, okay, as it stands today, 300,000 until 400. So almost 500,000. Okay, bedridden state with awareness. Okay, persistent vegetative state. It became like vegetable, vegetative, comma here. Okay, 180,000. Okay, eyes. All right, we come to the eyes. Okay, what's the value of the eyes? Not really value. What's the compensation for the eyes? Okay, loss of eyes. Okay, loss of eye is between 90,000 to 100,000. 100,000 lah, one eye. Loss of both eyes, 230,000. But the eyes, okay, whatever limb that you have, what is gone forever. It won't grow back kan, whatever limb. It's not like lizard can growing the tail. Okay, I want to show to you. Okay, this is, you can have a look later. The private part. Here. Okay, sexual organs. Here, okay. For men, that's the amount. Okay, not even 100,000, or even for the lady. All right, ovary 48,000. So both ovaries 97,000. Okay, that's the amount. Okay. We go back to the slide. Okay, we have less than 10 minutes now left. No worries. We still have tomorrow, okay, to continue. Just now, okay, I have shown it to you. I'm giving you a copy right after this so that you can have a quick look. Okay, and then it will be relevant for you when you're resolving problems later. Okay, especially if it is a open book, kan? I mean, you can refer to this one lah. Okay, but if it is closed book, then of course we don't expect students to be able to quote, okay, the estimation, okay, of the damages lah. Okay, sorry. All right, here. Okay, basically, okay, we are done, all right, at least, okay, we are done with general damages for today. The first part of it, general damages, which is we discuss pain and suffering. Okay, pain and suffering, no provision in Civil Law Act. Okay, I'm giving you Civil Law Act later. Okay, and then loss of amenities we discussed. Okay, you have to know that if plaintiff is in coma, can claim. Can still claim. Okay, but for pain and suffering, if the plaintiff is in coma, cannot claim. Okay, the plaintiff must be aware of the pain, must really feel the pain. I remember last sem, okay, what if the plaintiff took medicine, and then didn't feel the pain, isn't it? So can you claim or not? I mean, that was the question, I think, and the student need to discuss, and student keep on asking, madam, this one can claim or not? Because he or she didn't feel the pain, all right? So can we allow the claim or not? Yeah. So for you to think or for you to argue. And then mental anguish we discussed just now. Basically, it will be included together with pain and suffering. How do we know? From Civil Law Act, Section 28 to A and B. Injury itself, just now we refer to compendium. Okay, I mean the latest version is the revised version as at 2018, so applicable until today. Okay, we haven't come to loss of future earning. Maybe we reserve for tomorrow because it's a long discussion for future earning. Okay, we want to focus on the formula. Okay, now you have to do calculation. When you're resolving a problem later, whether you like it or not, you have to make simple calculation. Okay, I just show it to you quick here. Like this. Okay, I mean the age, okay, whatever age, and then divided by 2, and you have to calculate, okay, what's the multiplicand. Okay, multiplier is the year, the age. Multiplicand the salary. Tomorrow. Okay, we are going to focus on this tomorrow. Okay, and this is the calculation. Right, and this is example, okay, hypothetical example. Meaning here the plaintiff can get general damages, pain, suffering, loss of amenities, whatsoever, and special damages based on the receipt, okay, hospital bill, for example, and LOFE, loss of future earning, which is based on calculation, and we total it up all together, so can claim together all these things. Okay, and then we also have non-deductible sum. This is in reference to multiplicand tomorrow. Okay, this one we are going to discuss tomorrow, and this is the case law. Right, and we have a lot, I mean quite a number of cases lah. Okay, for LOFE, and then this is another part, LOEC. Okay, so we stop here because we still have tomorrow, so no need to worry. Okay, so we have come until this part, until this slide. So after this, so let me stop share. Thanks a lot for joining my session today. Stop sharing. And I'm stop recording.